Hi, my name is Dan De Saulles and I'm a commercial solicitor here at Harrison Clark Rickerbys, and today I'll be speaking about Endeavour clauses. So I'll be exploring how these have traditionally been used over time, some recent case law and how they've been interpreted quite recently up to date, and also I'll be looking at how to approach these in your contracts should you come across them, and also some kind of best tips and best practice as to how to apply them in contracts. So going back to basics then, as we know, contractual obligations are normally absolute. What that means is that obviously any breach of those will probably amount to a breach of contract. Now what an Endeavour clause does is it simply reiterates an attempt to do something. So a party will insert this type of clause into a contract without it amounting to that hard breach of contract. So English law recognises three traditional Endeavour clauses. The first one, reasonable endeavours. The second one, all reasonable endeavours, and the third one, best endeavours. Now I'll be talking through what each of these means and how they've been applied, but as a rough rule of thumb, if we think about it on a spectrum, reasonable endeavours is at the kind of less onerous end of the scale, whereas best endeavours is towards the top end of the scale. Reasonable endeavours, as I've mentioned, the least onerous of the three, and what this involves is balancing a party's obligations under a contract. So does it have to commit to any commercial detriment to satisfy that clause, or will it have to engage any other third parties, for example? Now, when interpreting this reasonable endeavours obligation, the courts have said, in the case of Minerva and Greenland Ram, and I'll read this for you, that what would a reasonable and prudent person acting properly in their own commercial interest and applying their minds to the contractual obligation have done to try and achieve that objective. Now, the interesting thing here is that the difference between reasonable endeavours and the other two, or especially best endeavours, is that a party is generally not required to sacrifice its own commercial interests, and that's quite a key point. Also, in the case of Rodier and Huntsman International, the courts have said that actually when looking at a reasonable endeavour clause, a party would probably only look to take one reasonable course of action rather than several different courses of action, and that's a difference between reasonable endeavours and best endeavours, as we'll see in a moment. Now, best endeavours, as I said, this is on the top end of the spectrum. It's by far the most onerous out of the three traditionally recognised endeavour obligations. And again, we have a definition which helps us at case law, which is in IBM and Rockware Glass. And again, I'll read this for you. So, to take all those steps in their power, which are capable of producing the desired results, those being steps which a prudent, determined and reasonable person would take, acting in that party's own interests and desiring to achieve that result. Now, interestingly here, the courts have actually recognised that to satisfy a best endeavours obligation, a party may well be required to commit some kind of commercial detriment. Now, the extent of that is of course limited and based on reasonableness. So you look at the context and how the contract would be interpreted as a whole, so taking into account the party's intentions. But the interesting point here, and I've mentioned it on the board, is it can't be recognised, commercial detriment or the utter disregard for stakeholders. So there is a limit to that best endeavours obligation. Now, importantly, this doesn't amount to what's called an absolute obligation. So yes, it's on the top end of the scale, but it's not recognised as sort of a guarantee for that specific absolute obligation. All reasonable endeavours. So this is pretty much the halfway point between reasonable endeavours and best endeavours. There's quite little case law actually on this topic and this interpretation, which isn't helpful. But what the judges have said is that actually this may be interpreted towards the top end of the spectrum, so best endeavours, and that's purely because you've got this commitment and the recognition that sometimes it could involve some commercial detriment to the party who's satisfying that clause. Now, as we're all probably familiar with, the recent AstraZeneca issue, they've been in dispute with the European Commission, and this involved a supply of vaccine doses related to COVID-19, so very topical. It's a current dispute at the moment, and there's pretty much two main arguments that's come out of this point. And the first one, what does it really mean to commit to a best reasonable effort or a best endeavour obligation? And secondly, and this is the term that was used in the contract, best reasonable efforts, is this commitment actually good enough, bearing in mind that there are supply chains at the moment amidst a life-saving vaccine in a global pandemic crisis. So the context of that second point is very key and will be really important as to how this clause could be interpreted if it does go to the courts. Now, one of the great difficulties before we proceed with the facts of the case in placing any great reliance on this is the fact that only part of the contract has been released into the public and part of that contract has been heavily redacted, so that's one to bear in mind. So AstraZeneca in this case pledged that it only used its best reasonable efforts to actually manufacture an initial vaccine dose for COVID-19. Now, interestingly, the best reasonable efforts is used 15 times in the version that we've seen in the public, so the redacted version. More importantly, though, is that best reasonable efforts has actually been defined in the contract, and I'll read this out for you. So it's defined as the activities and degree of effort that a company of a similar size with similar size infrastructure and similar resources as AstraZeneca would undertake or use in the development and manufacture of a vaccine at the relative stage of development. So what does this actually mean? Well, will that definition actually help? Possibly, and the reason is because, as we know, the best reasonable efforts clause has been used 15 times. So it'd be very difficult for that exact definition to apply each time the clause is used. What we do know is this obligation will probably fall somewhere between a full compliance obligation and a reasonable obligation. Again, if we think of that spectrum, where it will be applied is anyone's guess. Of course, it will be subjective and open to interpretation of the courts, should it get that far. So, in this scenario, if it were to go to the courts, how would this be applied? Well, this scenario would effectively require one to measure AstraZeneca's performance against that of the market standard. Now, the difficulty in doing that is that how does it happen when, of course, this is cutting-edge science? This vaccine is novel, it's new. We haven't seen this pandemic for a century or so. So how will the court do that if it does go that far? And that brings us back to the whole parties' intentions in a commercial contract. So that must always be key. What do the parties actually intend, or what did they intend at the time of entering into the contract? Now, of course, AstraZeneca have said that they're not strictly obliged to comply with this clause, whereas the EU have naturally said, yes, you are. You should commit at least significant efforts to achieving that result. Now, an important point also to note here is that the contract in question is subject to Belgian law. So globally, yes, we can look at how it would be interpreted, but there will be nuances in terms of the legal and the cultural application between English and Welsh law and Belgian law. Now, there's a few cases here I'd like to just quickly run through as to how Endeavour clauses over the years have been interpreted in an English and Welsh situation. First one is Jet2 and Blackpool, and this basically says that each case must be interpreted on its own facts. Fine, we know that. But such clauses must not be too uncertain to be capable of giving rise to a binding obligation. So here it was actually said that the best endeavours could require a party to act in its own commercial detriment, and that's something that we've seen progress over the years. However, that must always be qualified by reasonableness, so the party must not go to its own financial ruin, for example. Rhodia, which we discussed in the previous slides, emphasised that language is a key component, and that best endeavours are more stringent than reasonable endeavours, which kind of gives a bit of clarity to the distance between the spectrum. UBH is an interesting one, so it's unreported, but it does address this issue of what's meant by all reasonable endeavours. Saying that, it does just clarify that this is a middle ground between the two. Like I say, some judges have interpreted this towards the best endeavour side of the spectrum, but it doesn't crop up too often in contracts, as parties usually go with the reasonable endeavours or best endeavour option. But saying that, the most recent authority on all reasonable endeavours is CIS, Insurance and IBM, and this essentially states that it's not necessarily the same obligation as a best reasonable endeavours. What they both have in common is accumulation of this moderate, sensible steps approach which the parties have to take. And in many cases, there's no practical difference. But saying that, best endeavours could go further because of this whole detrimental, the obligor committing to this own financial interest and extraordinary efforts, which of course would be the differentiator here. Now, what else could there be in commercial contracts, and what are the alternatives? Well, there's three common alternatives that we've seen. They're on the slide for you. So commercially reasonable endeavours, reasonable commercial endeavours, which essentially means the same thing, and utmost endeavours. So like I said, all three try and suffer this endeavour obligation, again only making it a party's attempt to satisfy a contractual obligation. But interestingly, utmost endeavours, which I have seen a few times, but I do try and avoid it from a practical perspective, is very much seen as an advancement on this best endeavours clause. Now, what does that actually mean, and is there a new standard created on this spectrum? Well, I think Lord Hoffman sums this up perfectly, and I do agree with him, because I do think utmost endeavours is quite a confusing term. And he says that trying to distill a fixed meaning here has more in common with reading tea leaves than it does with legal reasoning, and I think that probably sums it up right. Utmost endeavours, I think, should be avoided if you can use best endeavours, for example, or even reasonable endeavours, because they are the more traditionally applied and interpreted and widely recognised terms. So what should we do in terms of the contracts in front of us now? How do we interpret these clauses, and should we use them? Well, the interesting point here is to always bear in mind what the practical step will be. Will the endeavour clause, which relates to a logical step, or will it be one with serious financial consequences? That always must be borne in mind. And that is outlined in the AstraZeneca case, and it's a good example of this. So can the best endeavours or reasonable endeavours clause be defined? If it can be defined, then just be careful as to how you define it. So for example, if you're using the clause often, will that same definition apply in each instance? But probably what's always will trump that consideration is communication between the parties. And it comes back to this intention point, which is widely renowned in English and Welsh law. So what do each parties expect under the contract? What will one party perform, and what will one party expect to be performed? Another useful approach could be to take and to document a steps approach. Now, of course, this will depend on a case-by-case basis and what the contract is all about, and I'll leave those on the slide for you to digest, but the two most important ones are the first two. So whether the obligor has to actually bear any costs in incurring any expenditure in satisfying that obligation. As we've mentioned before, that will be concurrent and more towards the top end of the spectrum, so best endeavours, and the period for which obviously the obligor should pursue that objective. So if you're using reasonable endeavours, for example, to gain consent of a third party, will that be forthcoming in the next 3 to 6 months, or will it be a longer obligation for example, 12 to 18 months? Obviously always consider that in mind, and how quickly one party can resolve and satisfy that obligation. So some takeaways today then. The crucial point to note is that obviously when you're entering into these contracts and you're negotiating these clauses, the interpretation and the party intention are at the time of the contract. However, when you're looking at undertaking and satisfying that endeavour obligation, of course that's looked at the time of performance of the contract, which could well be 12 months plus, depending on the length of the contract. Second point, always consider whether what you're drafting or the endeavour clause which is used is enforceable at all. If there's an underlying objective there which both parties are unsure about, or they both don't intend the same thing, then of course any endeavour obligation is not going to satisfy that particular clause. And crucially, and I think it's probably the most important point of the three, and a key one to take away today, is will the obligor actually take steps to comply with that endeavour obligation? So for example, have they just inserted that clause in there to get around the absolute obligation, in terms of if they fail, they'll breach the contract, as we mentioned earlier? In all the case law which we've seen on endeavour obligations, a lot of the time, instead of focusing on the nuance and the drafting of the legal clauses and what it actually means, look to the parties' intentions again and the practical steps that they should take. So for example, will the parties actually take proactive steps and document those steps to show that it has actually performed or tried to perform the endeavour obligations? Thank you very much for listening. If you have any questions at all, please do contact me.